In 2017, Philadelphia resident David Jones was shot in the back and killed while running away from police officer Ryan Pownell. Jones's family wanted justice, but as you probably know, police officers are rarely charged with murder. Cops in the US kill nearly 1,000 people a year, but only around 130 officers have faced criminal charges in the last 15 years. And although Black Americans are only 13% of the population, they are killed by police at more than twice the rate of white Americans. But David Jones's murder was different because DA Larry Krasner decided to charge Officer Pownell with criminal homicide.
There has not been prosecution of police misconduct, police murder, police abuse by this DA's office for 30 years.
Krasner is trying to reform the justice system in Philadelphia, but many other prosecutors are hesitant to bring criminal charges against police officers. There's another option for the victims of police violence, however, and that's filing a lawsuit in civil court. The Civil Rights Act of 1871 says that anyone whose rights have been violated by a public official can sue for damages. The problem is, these cases are often thrown out before they can even begin because of something called qualified immunity. Tracing back to 1967, qualified immunity protects government officials from civil lawsuits unless the person violates clearly established law. And the phrase clearly established is important. Most courts interpret this to mean that there must be another previous case with almost exactly the same details, or the suit will be thrown out. Between 2005 and 2019, courts used qualified immunity to favor police in roughly half of the cases. One example is the 2006 murder of Colorado resident Ryan Wilson. Wilson was running away from police when officers aimed a taser at his back, killing him as he fled. When his family tried to sue, the case was dismissed because no other case had clearly established that tasing a fleeing suspect was an illegal use of force. This can become a self-perpetuating cycle, with qualified immunity keeping cases from going to court, which makes future cases harder to try. So why does qualified immunity even exist? It's supposed to protect government workers from frivolous lawsuits and from having to pay large sums of money for doing their jobs in good faith. Police officers say that without qualified immunity, they wouldn't be able to act quickly in stressful situations for fear that making a mistake could get them sued. As a result, public safety would suffer. But when victims of police violence seek compensation, they can sue police officers' employers, which are often local governments. Financial damages are therefore paid by taxpayer dollars, not by officers. Philadelphia alone pays an average of $10 million a year in restitution, and most of the time these settlements don't come out of police budgets. Opponents of qualified immunity argue that all it does is serve as a roadblock to holding police accountable. So what's being done to change it? Colorado's state legislature took steps to limit qualified immunity in 2020 by passing a law saying qualified immunity can't be used to dismiss civil suits in state courts. New Mexico passed a similar law this year. But in states like Pennsylvania, qualified immunity still blocks many civil suits from moving forward. To see what happens when an officer is charged with homicide, watch Philly DA, a docuseries about trying to change the justice system from the inside. Stream it on the PBS Video app.